Banerjee. I'm an immigration lawyer in Houston, Texas, and today we will talk about the Perm process. The Perm process is the first process usually in an employment-based immigration green card. It is the first process usually when the employer petitions for the employee to get the green card of the United States. Again, this is employment based. It has nothing to do with family, and because it is employment based, it has to do with the relationship between the employer and the employee. In the first step, the employer has to prove to the Department of Labor, note, not CIS, this is with the Department of Labor. The employer has to file a Perm petition to the Department of Labor saying that, look, we conducted recruitment and we cannot find any American to do this job here, and so we have to give the immigration to the employee so that employee can continue to stay or come in with the green card process and continue the work here. Before we go into a further discussion of the Perm, I would like to take this opportunity and give you a very brief overview of what was happening before 2005. Before 2005, we used to file forms to the Department of Labor. It was called the 750A and the 750B. The 750A was the employer's document saying that, look, we recruited we had recruitment and this is what we have. And then the employee's document was basically saying that this employee does meet our requirement, and therefore, because there is no other employee that can do this job who are American citizens, we have to give the green card to this employee. Now, what would happen very often before 2005 is that there were a lot of corruption. A lot of corruption going on. Very often the employee would come and the employee would ask the attorney to do the job, and employers didn't even know what's happening. They would just maybe sign documents, and they had no idea. They said that, I've talked to employers back in those times, and employers were like, yeah, we filed something, we did his green card. But they have no idea what was going on. The process was controlled the process was completely controlled by attorneys. And in fact, I think Fragoman, the attorney, the big law office, Fragoman, they used to themselves conduct the interviews of the clients, of the people who are applying. So there was a lot, and they are not supposed to. Attorneys cannot. We don't work in HR departments. We cannot conduct interview with applicants. So basically what would happen is that the employee could go and pay a lawyer, and the lawyer would control the whole process, have the employer sign and send it off. Also, because it was possible at that time, the law was such that employees and employers would actually file the permanent residency and if the employee no longer worked there, that permanent residency was valid to be used by anybody else who was qualified to do this job. And what happened was that folks understood, and very often what happened was that those permanent residencies would be sold. I was told that they would be sold back in 2005 for like $10,000, and I have no idea whether the $10,000 was part of what the attorneys charged or the employers charged, but yes, there was a lot of fraud going on. And to stop that, the Labor Department came up with this system in 2005 called the permanent system. The Perm system is completely based on the internet. It is a fast system. It is compared to what it was before. It is an internet-based system where the employer has to create an account. Then the employer has to go in that account and then get the attorney as their attorney. So the attorneys will not be able to control that process. The process needs to be controlled by the employer. And also very important to know that for this process, employers have to pay for the entire perm, including attorney's fees as well as recruitment fee, advertisement fees. So that the attorneys or the employees do not control anything. The attorneys are here to help, obviously, because as with anything in the law, if it was easy, then it wouldn't be necessary to have attorneys. But also remember that there is nothing that bars the employer to file it themselves without an attorney. So what happens? Say the employer and employee comes to an attorney and says that, look, we can't find anybody. This employee is amazing. So let's start the permanent process for getting this employee here permanently so that I, the employer, don't have to go on searching for people to do this job. So then what happens is we first ask them, well, what kind of job is it? We get the employer's input into what kind of job it is and what is the minimum requirement to do this job. Now note, the employer might want somebody, say, educated at Harvard or whatever, but that is not the standard. The standard is that what is the minimum education or experience required to do this job. So if the minimum requirement to do this job is a bachelor's degree and the employee has a master's degree, then tough luck, because it is the minimum requirement to do this job, and the employee will be in EB3 even though he himself has a master's degree. So the employer might prefer a better educated employee, but there is no choice. What is the minimum requirement to do this job? So then we come up with the job description, and usually we will send it to the Labor Department again to find out what the prevailing wage is. The prevailing wage, the Labor Department has come up with a new website called the flag system, and I hope that the flag system will make things faster, but again, we don't know right now. I have not seen any difference in time for when we used to file in their previous system, iCert, versus the flag system to get the prevailing wages. The prevailing wages is basically somebody has to go through the job and figure out what SOC code it should be. Attorneys can suggest SOC codes, but it's up to the Department of Labor, and then they usually will give the prevailing wage that is necessary for this job. Why is this necessary? Because the employer cannot hire somebody from, say, someplace where and pay them peanuts and not hire American citizens. The employer has to hire at the salary that is what the salary that is prevalent, the wage that is prevalent in that market in that time for that job. And the Department of Labor comes back and controls the process, and they set down a prevailing wage. After we get the prevailing wage, now please realize that sometimes the Department of Labor's calendar starts from July 1, and so what happens is that sometimes the Department of Labor, if we say file a prevailing wage application in March, they will come back say in May or June, and they will just have the approval from May 25th to say July 25th, and it sometimes they give us very little time to advertise, to go through with everything, contact people. It's just nearly impossible sometimes, and we just have to wait and file it in June so that they will get it in the next year, which starts from July 1st. So the prevailing wage is usually valid from whatever date the Department of Labor gives that prevailing wage until the last day of that fiscal year for Department of Labor, which is 6/30/2019. Sometimes if it's not even a month, then they will give it for a little bit more, but again, it's always good to have more time so that the employer can go over all the applicants, they can interview them, they can get the interviewees there. I mean, there's a lot of time that goes on. So once you advertise, the advertisements are valid for 6 months only. The advertisements that you have to advertise in are, number one, in this Department of Labor's website. They have a website, they want to use it. So you have to advertise with what is called the State Workforce Agency, a Department of Labor agency, basically, which works with the state. You have to advertise in their database, and you have to hold that for a few days for veterans to apply, and then once it goes to the general population, then you have to advertise for a whole month there. You also have to advertise in 2 Sunday newspapers, in the major newspaper of that area. So if it's New York, it's New York Times. If it's Dallas, it's Dallas Morning News. If it's Houston, it's Houston Chronicle. So you cannot choose, for instance, if you're in New York, you cannot choose New York Post, because the New York Times is the major newspaper with more circulations there. Now many employers says the newspaper, who reads those? Well, Department of Labor does, obviously. So and then we can advertise in 3 other places. That can be in colleges for recruitment. It can be in the employer's website where they ask people. It can be in Monster. We very often advertise in places where people will actually look for those jobs. So like wherever they will be looking, wherever applicants will be looking for those jobs. Once we finish the advertisement, then what we have to do is also have a notice that is posted in employer's website saying that the employer is filing this labor certification. After all that, what we then have is we then go through, we will get resumes of people, and the employer has to go through those resumes and see if anybody qualifies. If anybody qualifies, then the employer has to call them for an interview or talk to them over the phone. And if they are able and willing to do this job, then the employer has to give this job to that American citizen and not file the perm. Now, say they advertise, and very frequently what happens to us, if it is a very technical job, nobody even answers that, the recruitment. And bear in mind, the employer probably have actually undergone actual recruitment before they could settle on this employee. So after all that is done, then the employer, after the recruitment is done, if there are no American citizens to do this job, then the attorney files the perm application, or the employer can file the perm application. The Department of Labor is currently taking about 5 months to approve. The Department of Labor also can audit, i.e. ask for all the advertisements that were made, all the people who applied, and see if anyone qualifies for themselves. That's called an audit, and an audit takes about 5-6 months more. And once the Labor Department is satisfied that there are no American to do the job, they will certify that perm, and the employee can go on, or the employer and employee can go on to the next processes. Thank you.